Hello everybody and welcome to this webinar. I'm Roz Goldstein from Goldstein Legal. We're a specialist firm of franchise and commercial lawyers. Today we're talking about franchise resales, how you can go about selling or buying an existing franchise and how to get your deal done. Now, selling or buying a franchise, it should be a good news story and it should have happy people all round. If you're an existing franchisee, it should give you an opportunity, if you have a buyer for your business, to sell up and make a good return on all the money that you've invested in the franchise during the term that you've been running it. For a buyer, an incoming franchisee, they're getting a business which hopefully is already up and running, making money, and which the buyer can hopefully develop further. And for the franchisor, it's potentially a hugely positive PR story. Any franchise owner would like to be able to say that franchisees who buy into the system and operate the business successfully have the opportunity, if they want to, in time, to sell their business and potentially, in some cases, to really make quite a lot of money. But unfortunately, despite all of this, if a franchise resale is not managed correctly, then all too often it descends into some sort of protracted series of rows, hostilities, disappointments, and in a worst case, the deal falls through altogether. Unfortunately, we see this happen all too often. So what I'm going to talk about now is the legal process. How does a resale work and what are your options in terms of doing a resale? We hear a lot about asset sales and share sales. What's the difference and which one is better? What can go wrong and how to ensure that resales complete successfully and that all the parties involved get the best value out of it. So to start with, here's a picture showing you all the different people who are involved in a franchise sale. And this explains, at least in part, why franchise resales can be complicated. It's because there's so many different people involved. In the middle at the top, you can see a little face with an F underneath it. That's your franchisor, the person who owns the brand. To the left, the S is the seller, the person who's already running the franchise and is looking to sell. To the right, you've got the buyer, the person who's looking to buy into the franchise. Underneath that, by the pound sign, well, that's the bank or the investor or the lender. And normally they're lending money to the buyer in order to manage the sale. At the bottom, by the I, that's the introducer. There's in most cases somebody who has introduced the seller and the buyer to each other, and the introducer most times is going to get paid, so they also want to see that the deal goes through. By the LL, well, that's the landlord, and we'll come on and talk more about landlords a bit later. The red faces I thought I would just put on there to indicate all the potentially different sets of lawyers that you've got involved. The franchisor, the seller, the buyer, the landlord, and also to the left where I've put SLL, that's a superior landlord. And again, I'll explain more about that later. All of those people are going to have their own lawyers involved. So you need to make sure that all of them are on side. The little blue faces, those are the accountants. Almost certainly, the seller and the buyer ought to have their own accountants, and those accountants ought to be involved in the selling process if it's going to go well. So let's just look briefly at what an asset sale is and how it works. On an asset sale, it's what people term as the sale of a business as a going concern. And this is probably the most frequent way that franchise resales happen. In an asset sale, it is the company that is running the franchise that is the seller. So if you set up a franchise and you buy a franchise and your name is Joe Bloggs, most likely you'll set up something which could be called Joe Bloggs Limited for the sake of argument, that is going to be running the franchise, and that'll be the franchisee under the franchise agreement. In an asset sale, it's Joe Bloggs Limited that is the seller of the business. And the limited company has then got the assets and is selling them on. The assets are going to include everything that you need in order for the business to run as a going concern. So that's going to be things like stock, contracts with customers and suppliers, staff, equipment, fixtures and fittings, and what is nebulously referred to as goodwill, which basically means people's custom and the reputation and the regard for the business. It's often perceived that on an asset sale, there is less risk for the buyer. There is in some ways, because on an asset sale, you are literally only buying those assets that have been listed in the sale contract. Another thing you've got to bear in mind is something called TUPE, which refers to transfer of undertakings rules on staff. If you are selling a business by way of an asset sale, if you employ staff, all of those staff are going to transfer to the buyer, and that is whether the buyer wants them or not. You cannot contract out of it. That can sometimes be a stumbling block for people looking to buy into a business, but who don't really want the staff. And then the other key thing to think about is the landlord's consent. As I said earlier, landlords and sometimes even superior landlords get involved at this stage. If you have a lease, if there's a lease in the name of Joe Bloggs Limited, you will need the consent of the landlord to assign that lease to the buyer company. And therein can often lie a lot of the problem. If there's a superior landlord involved, there's additionally an extra party to be considered. Now let's compare that with how a share sale works. In this case, the seller is not the company itself, but the owner of the company. So going back to my previous example, if you're Joe Bloggs and you've been running a franchise under the name of Joe Bloggs Limited, on a share sale, the seller is you, Joe Bloggs. And what you are selling is the whole company, lock, stock and barrel. A colleague of mine came up with a nice analogy for this recently in terms of how to understand the difference between an asset sale and a share sale. If you imagine that your business is a box and the contents of that box, on an asset sale, it's like you're opening the box and you're selling the contents off to somebody in one go. That means you're left with an empty box, i.e. your limited company. But on a share sale, you're selling the whole box, not just the contents. So the buyer takes the whole limited company with all historic liabilities in it, including potentially any tax liabilities. It can be perceived that that is a higher risk for the buyer. It can be better for the seller because the seller is getting rid of the whole business, and in theory they're selling all of the assets and all of the liabilities all at once. In reality, it doesn't make that much difference because there are ways to manage the risk and to share the risk between the parties in both cases, whether it's an asset sale or whether it's a share sale. You look at having decent warranties in place, and of course the buyer needs to be doing their due diligence on the business. And then in some cases, if it's a share purchase, the buyer is going to expect the seller to be giving a tax covenant under which the seller will go on being liable for any hidden tax liabilities. On a share sale note, it may be that the landlord's consent is a much easier thing to deal with because in most leases, the landlord doesn't have to give their consent to a change of control, a sale of shares. But they do have to give their consent to an assignment of a lease. So you often find with share sales that the landlord's consent issue is not a problem because we don't have to talk to them. You do have to check the terms of your lease though, however, so that's something you need to get your lawyers to look at. So which route to choose? In all honesty, the cost implications of both are quite similar. And the levels of risk for the buyer and the seller, well, as I've said, there are ways of managing that and apportioning and sharing the risk, whichever way you look at it. As per my last bullet on that slide, yes, it is worthwhile considering landlord's consent issues. It does have an impact on the timing. The landlord has absolutely no vested interest in seeing your business be successfully sold. They don't care whether it's you paying the rent or a new buyer coming in that's paying the rent. That does mean that in most cases they drag their feet. So in terms of timing, there can be some real benefits to doing a share sale rather than an asset sale. But the most important thing to bear in mind, which I've underlined on this slide, are the tax and the accounting considerations. Most likely the most significant factor steering you towards a share purchase or an asset purchase are going to be the tax and accounting issues that arise, because the tax treatment of both is quite different. Hence why you need to be talking to an accountant to understand how that is going to pan out for you financially one way or the other. So let's touch on things that can go wrong. And in pulling this list of things together, I'm looking at, because I do a lot of resales, I'm looking at what most often are the blockers and obstacles that cause problems. The first issue sounds obvious, but with everybody's enthusiasm for a potential sale or purchase, the parties can get carried away and start looking at it and making plans before the buyer's bank funding is confirmed. If you are a seller, common sense dictates that you will make sure that your buyer has actually got the bank funding before you go too far down the line and get too excited about the potential for your sale. Because people may say that they've got funding and it's just because they've started speaking to a bank. But sometimes banks can be slow, they can take time, and sometimes funding gets refused. As I said earlier, the single next biggest factor is landlords. As I said, they've got no vested interest in achieving a transfer of the property. So if we are looking at doing an asset sale, and we do need to get landlord's consent, what we do at Goldstein Legal is start working on getting that landlord's consent right at the very first possible moment, because it generally takes the longest. Now, unrepresented parties. I would put that third on my list of things that can make a resale deal go wrong. Looking at the slide I showed you earlier with all those different faces on it, I can understand the temptation to start cutting people out of it and saying, well, if I just have less advisors, maybe it'll all go through more quickly rather. But unfortunately, it doesn't work that way. If you try and cut advisors out of the process, it tends to come back to haunt you later, because at some point or another, somebody realises that they needed to get advice, and you're then scrambling about trying to get people to provide input when they weren't involved at the outset. Lack of awareness of the process, I'd link that to my previous point. You've got to be realistic about it. You have to allow for the fact that a franchise resale, just like any other business sale and purchase, takes its time, and there will be a voluminous amount of paperwork. You can't do it on one side of A4 paper, much as the parties might like to think that they can. At the end of the day, you're going to need to have a decent set of documentation. So don't let anybody delude you that that isn't going to be necessary. Obstructive advisors. I don't like putting this on the list, but I do have to. Sometimes advisors, whether they're accountants or lawyers, get more sidetracked into pointing out how clever they are rather than actually letting the deal complete and working towards getting the deal done. So I'll come on to this later, but there is an important point about who you choose to be your advisors and making a wise choice. Lastly on the list, I've put accountants having a lack of expertise. This is a problem that arises sometimes. It's a question of horses for courses. You may have an accountant that does an excellent job of your bookkeeping, but that does not mean necessarily that that accountant knows how to give you tax advice in relation to a share purchase or an asset purchase. There will come a point in the process where the accountants will be dragged in to advising and reviewing and confirming information relating to tax warranties. So if your current accountant is not an expert in that field, there's no shame in that, but it's worthwhile finding it out at an early stage, because if they're not expert in that, you're going to need somebody else who is to support you. So let's just have a look at some of the solutions. First on my list, I'd put the timing of the due diligence. If you're the buyer, you want to start making your investigations of the business you're buying at the earliest possible stage. And if you're the seller, you want to check with your lawyers when they are going to start putting together paperwork for the due diligence disclosure process. Nowadays, due diligence disclosure is almost invariably done online, in the cloud, and what the seller's lawyers ought to be doing right in the early stages is pulling together all the documents, putting them on a cloud file, inviting the buyer and the buyer's advisors to have access to that file so that all the parties involved can start looking at the key documents that they need to look at. This is going to be things like the accounts, copies of contracts, details of the staff, payroll information, and all of those kinds of things. The next point, as I mentioned earlier, getting the right advisors in place. When it comes to lawyers, it's going to work much better if the lawyers that you choose, whether you're the seller or the buyer, if the lawyers that you choose are used to doing franchise resales and do them a lot. There aren't loads of us about, but there are a few of us about, and it is worthwhile talking to lawyers to make sure that they are used to doing this kind of process. You may know a really good lawyer who helped you draft your wills a few years ago, or somebody who may have been great at doing your house purchase, but that does not mean that they're going to be good at doing a franchise resale. It's a completely different speciality. And at the other end of the spectrum, you don't want to go and use necessarily a top firm of city lawyers unless you're going to be spending multiple millions of pounds on buying the business. You probably want to use a smaller firm who are used to doing resales and business purchases for the kinds of values that you are looking at in relation to your particular transaction. The next thing I mention, be realistic about the timing. It is, as I said earlier, going to take time. The best thing that you can do is get your advisors in place early and make sure you're picking advisors who are going to push through all the things that need to be done early, particularly, as I said, for example, in relation to getting landlord's consent. The involvement of the franchisor can help. And again, the earlier you talk to the franchisor, the better. If you're an existing franchisee and you're looking at selling, I would never understand the logic in keeping it as a surprise for your franchisor. They might as well know early. There's nothing really to lose by them knowing early. And you're going to need the franchisor's buy-in anyway. They're going to need to approve the buyer, or they may even have a pipeline of potential buyers who might be interested in buying your business. So speak to the franchisor early. Now, the interesting thing in this context is that some franchisors who have very well developed systems and are very well organised actually have a clear process in their operations manual, setting out exactly how a franchise resale ought to work. There's a lot of logic for this because, as I said at the start of this webinar, it can be a tremendously good news story for franchisors for them to be able to show that their franchisees are selling businesses and making good money in the process. So some franchisors have a designated section in their operations manual that sets out exactly what the franchisor's expectations are, exactly how the resale document is going to work, exactly how the franchisor's lawyers will draw up the sale and purchase agreement. And some franchisors even set out parameters for how you can calculate approximately the sale value of the business that you're looking to sell, how much you should be looking to get. So that is a quick snapshot of issues relating to franchise resales. I hope that's been helpful, and thanks for listening to it. Please, if you want further information, do take a look at our website, or if you want further advice, please get in touch with us. The details are on the screen in front of you now, and we'll be happy to talk to you. Thank you.